Have a seat.
I'm not.
Have a seat.
Your Honor, I haven't had.
Have a seat. Did you understand what I just said?
Can we agree to disagree on the legalese?
We are not going to agree to anything. This is not your game to play here.
So you're saying that I have to say the words "I understand"?
Sir, I'm not saying that you have to say anything. You can play games with me all day. I got all day. I got all day. Have a seat. Do not interrupt me.
I can object to
Do
that.
not interrupt. Do not. One more time. You're going. In this matter, sir.
Yes, sir.
I do have to advise you that in this case, you are charged with the offense of assaulting, resisting, or obstructing a police officer. That is a high court misdemeanor felony, punishable by up to 2 years and/or $2,000 fine plus court costs. You understand that?
Right away, we're seeing a collision between a judge trying to establish a clear record and a defendant who seems determined to answer every question except the one being asked. This may sound like a minor disagreement, but in court, simple yes or no questions often have a very specific legal purpose. And trust me, the judge already looks like he's running low on patience.
I understand your charge.
You understand also that there is great peril in one representing themselves. You understand that, sir?
I'm not afraid, Your Honor.
Did you understand what I just said? That there is great peril in representing oneself.
I comprehend what you're saying, Your Honor.
Hey, what? Either you're going to answer my questions and you're going to answer them properly, or we're going to have a long time and I'm not going to have these people wait. So while you decide how you're going to handle this, I'm going to have you have a seat. I'm going to pass your case. You will come back up and you will learn how to operate within this court. Plain and simple. Have a seat. Have a seat.
Did you catch that comment about the smirk? That's a clue that this hearing is no longer just about legal procedure. It's becoming personal. Judges are human beings, and courtroom demeanor matters. Fair or unfair, the way you present yourself can influence how your arguments are received. What do you think? Is the defendant standing on principle or creating problems for himself?
And you might want to wipe that smirk off your face while you're doing it. Say your name.
Good afternoon, Your Honor. My name is Daniel Magoo.
I have stated the admonishments that I was giving to the defendant representing himself. I apprised him of the maximum penalties and the charges. Apprised him, and sir, I'll ask you the question again. You understand that there can be great peril in representing yourself?
I fully recognize and acknowledge the seriousness of the charges, which include allegations of...
Not my question. You understand that there can be serious peril in representing yourself.
I recognize what you're saying, and I'm fully prepared to proceed with this matter.
Will you just do me a favor and answer my question? Do you understand that there is great peril in representing oneself?
I recognize that.
Okay, then stop there.
Yeah.
You recognize it.
Recognize.
Do you understand that that in any of the proceedings that the court would hold you to the same standards as if you were a practicing attorney, will give no leeway one way or the other, will show no favoritism or no bias because you are representing yourself? You understand that, sir?
I recognize what you're saying, Your Honor.
You know what? I don't know why you just won't understand. I'm asking you, and I need a direct answer, whether you understand what I am saying, not whether or not you're recognizing the words. Do you understand what I am saying?
I overstand what you're saying.
You want to be...
Your Honor.
You have a seat.
I'm not...
Have a seat.
Your Honor, I haven't had...
Have a seat.
Now we've entered the territory of what's sometimes called sovereign citizen-style communication tactics, where ordinary legal terms are replaced with alternative wording like recognize, comprehend, or even overstand. The problem is that courts generally care about clarity, not word games, and the judge is making it crystal clear that he's not interested in debating vocabulary.
You can play games with me all day. I got all day. I got all day. Have a seat. The other one's in custody. I realize we are now at least caught up within an hour. I think those that want to go probably want me to take a break about now. So I'm going to take about a 5 to 10 minute break. I'll come back out and then I'll call the case. The court's going to stand in recess.
Good afternoon, Your Honor. Daniel Magoo. Here in, Dewey Juris.
All right. So on this matter, I was apprised you of your rights. I told you about the charges in this case. We get to the point of understanding that there is a certain peril in representing.
Listening, sorry. My notes, I apologize, Your Honor. But no disrespect.
The court will treat you the same as an attorney in the case. You understand, sir? Listen closely to my question. Do you understand that?
I do not understand.
You do not understand it.
No.
The court, you will be presumed to know the rules of procedure as well as the Michigan rules of evidence, that the court will not be giving you assistance in regard to this case.
What I'm trying to say, Your Honor, is I do not understand the charges that are pitting against me because they violate a lot of my rights. And the prosecutor served me the discovery packet on the 27th of last month. Since then, I have not received any kind of evidence or any kind of claims that I violated any kind of anything that day. So I'm here waiting for that to occur. So no, I don't understand.
Waiting for what to occur?
Well, under the rights to due process, Your Honor, 4th, 5th, 8th Amendment, there has to be substantiated amount of evidence to accuse me of a crime, like assault on a police officer, obstruction of justice, and resisting arrest. I take these charges very serious, Your Honor. Because of these charges, I have lost custody of my son, and I want to make sure that these justice is served and equity is ensured here.
Sir, I just asked you before whether or not you understood the charges.
And I answered you, Your Honor. I said I do not understand them.
Whether or not you disagree with them or not, it's not the issue. The issue is do you understand what you are charged with?
Here's the fascinating part. The defendant keeps trying to argue the merits of the case, whether the charges are justified, while the judge is focused on something much simpler. Does he understand what he's accused of? Those are two completely different legal questions. It's like showing up for a driving test and trying to argue about traffic laws instead of answering whether you know how to operate the car.
I do not understand, Your Honor.
Is there a reason other than what you said that you do not understand?
I can elaborate a little further, Your Honor. I'm still
I
waiting.
wish you wouldn't. I just need to understand why you don't understand.
I'm trying to get there, Your
charges.
Honor, if we could talk
I'm
about it.
not asking you whether or not you agree that you should be charged. I'm not asking whether or not you believe that you did it. I'm not asking any of that. I'm asking whether or not you understand what you are charged with.
Can we agree to disagree on the legalese?
We are not going to agree to anything. This is not your game to play here. You play by my rules.
So you're saying that I have to say the words, I understand?
Sir, I'm not saying that you have to say anything.
Okay.
You know what? Here's the thing. I am not going to play this game with you.
I'm not.
So what? No, you are playing a
I'm
game.
not.
So no, you are. And do not interrupt me ever again. Do not. So what I'm going to do is I'm going to give you a week to think about it, because I'm not going to sit here, call your case up 4 or 5 times for you to sit here and to go through this whole, try to play some semantical game. So I will adjourn this out to December 12th, 2024. I will adjourn it to 9 a.m.
Your Honor.
or I will, do not interrupt me.
I can object to
Do
that date.
not
Prior
interrupt, do not. One more time, you're going. I'm adjourning the proceeding out. If you are objecting to that, objections noted. It's still adjourned out to the 12th.
And there it is. The judge has officially concluded that this isn't confusion, it's deliberate obstruction of the conversation. Notice what's happening procedurally. Instead of escalating immediately, the judge grants more time and adjourns the matter. That's actually a restraint move. He's essentially saying, come back when you're ready to participate in the process.
Bond will continue. You
Your
may
Honor.
leave now.
I have constitutional.
You may leave
violation.
now.
Let's go ahead. Understood.
I have a right to
You
a
may
counsel.
leave.
Do I not have a right to a counsel?
You want an attorney, you may get on an attorney, sir?
I need somebody to explain the problem here.
Do you wish to be represented by an attorney on this?
I do not need to represent myself. I'm presenting myself. I'm the only one that was there in this courtroom. No one was there. I don't recall anybody that was there that day. I'm the only one that knows what happened, Your Honor.
Do you wish
And I was
to be
violated.
represented by an attorney? I'm not going to sit here and argue with you. If you wish to be represented by an attorney,
Your Honor, I have constitutional violations.
do
that
you
need
wish to be represented by an attorney,
to
sir?
take an oath to defend the Constitution of the United States of
Then
America.
if
This ending tells you everything you need to know about how the hearing unfolded. The judge asks a direct question about legal representation. The defendant pivots back to constitutional grievances. The judge asks again. Another pivot. At some point, courts stop debating and start managing the courtroom. The result? Removal from the hearing. So here's the question for the comments. Was the defendant defending his rights, or was he talking himself into a worse position with every answer?
you do not want to answer my question, Mr. Allen, he is to be removed from my courtroom.